Okay, welcome everybody. CIJ wide, statewide audience and friends of CLCs and VLA alike. It's fantastic to have everyone along to what I think is our last webinar for the year, unless I'm missing something. And my name's Elena Campbell. I'm an Associate Director at the CIJ. And obviously, before we go any further, I want to acknowledge the traditional custodians of the many lands from which we're joining today. For me, that's the lands of the Boonwurrung people down on the south coast of Victoria. But wherever we are, I want to acknowledge that these lands were never ceded and always were and always will be Aboriginal land. And obviously, as we draw to a close of a second really tough year, a lot of challenge and change, I want to in particular acknowledge the strength and resilience of Aboriginal communities around Victoria who have really kind of set the scene and led the charge of how to look after each other, from which a lot of Victoria-wide or Australia-wide, there can be lessons learned in that regard, I think. I also want to acknowledge, obviously today at the final day of the 16 days of activism, many victim survivors of gender-based violence, both in Victoria and around Australia. It's been a busy 16 days, and today, on the final day, on Human Rights Day, we want to acknowledge the fundamental premise of legal advice and assistance as being part of that human rights framework. It's sometimes something that's always often missed, particularly when we think about our response to gender-based violence. We think about accountability, doing things to people, and we think about the specialist response to provide safety and support, but we don't necessarily kind of think about how access to legal advice and integrated support within that can make the difference to safety and people's experience of the process. And the context for this webinar today is really a shared interest across the CIJ, across ARC Justice, Youthlaw and VLA and their participating CLCs, looking at various different angles about the importance of legal advice and the difference it can make to safety in intervention order matters. From the CIJ's perspective, we've done a lot of research in this area, particularly a big piece a couple of years ago supporting the implementation of Recommendation 77 from the Royal Commission, looking at the process around intervention orders that are made by consent. Now, the vast majority of intervention orders are made by consent, and that is as it should be because we couldn't have everything running to contest. But for anyone who's working in and around the system, we know that there isn't really a process. It's the churn kind of pushes matters through without necessarily people having access to the kinds of information that they need to make decisions, to inform their understanding of what's happening and to get them linked into appropriate support and safety, which can improve their safety. So there's a link to that report will be published in this chat. But today we're here to talk about look at this question of legal advice from various different angles. So the discussion will feature findings from ARC Justice's research into the needs of affected family members in regional Victoria. We'll hear about reflections on the benefits of providing pre-court support to young people from Youthlaw and reflections on the emerging benefits of pre-court support from Victoria Legal Aid. And throughout, we'll hear from each agency in turn and then hopefully have some time for questions at the end. So feel free to put your questions in the Q&A function as we go. And we will try and answer them actually either during, because sometimes that's possible, we can weave things in, or if we have time at the end. But if we don't actually have time, then we'll find another way to keep people in the loop with what's happening and to follow up answering your questions. But for now, I just want to hand over first to the fabulous people from ARC Justice, and kudos to them. It was their idea for this webinar, not ours. We just stepped in to help it pull it together. So I want to hand over to John, Kate and Eva from ARC Justice, who are going to take us through their recent research into the needs of women listed as AFMs on police initiated orders, and through 3 different areas of focus. Okay, I hand over to you, John. First, John.
Thanks, Elena. I'm just hoping you can hear me. Yep, all good. Okay, great. Yeah, thanks for that introduction. My name's John. I'm a Senior Research and Evaluation Advisor with ARC Justice. Also want to acknowledge that we're all meeting on different country today, so I want to pay my respects, extend gratitude and to the traditional owners, leaders and elders of the various lands where we're now meeting. I'm on Turrbal and Yagara country up here in southeast Queensland. And I just want to acknowledge also that the issues we'll be speaking about today, I think, are that much more acute for Aboriginal and Torres Strait Islander people. So, you know, they're already fighting for access to justice in so many ways, not to mention the implications of, you know, increasingly carceral responses to family violence in Australia. So I guess we need to be mindful of that as we discuss our insights and make recommendations in these sort of conversations. So thanks, Elena and RMIT Centre for Innovative Justice for convening this with very little notice and zero resources. So very much appreciate your support. And speaking of resources as well, we just want to acknowledge the Victoria Law Foundation from our side, who provided the funding throughout their Knowledge Grant scheme for our research project. So thank you. So our research was undertaken by a team at ARC Justice. We provide legal help and tenancy advocacy services to people in central and northern Victoria. We work across 2 headquarter courts and 8 satellite courts in those regions. And just as a background to the project, I mean, I think we all know fairly well the Royal Commission reform agenda, and that as part of this, family violence intervention orders have become a central legal mechanism to disrupt and I suppose in a civil sense denounce perpetrators of family violence, and in theory create some protection and safety for people experiencing family violence, of which we know the overwhelming majority are women. We also know the majority of IVO applications are now made by police. So this trend is having an impact, but because we don't precisely know what sort of impact, and it hasn't been well documented. So specifically with reference to regional Victoria, ARC Justice set out to understand how the increasing centrality of intervention orders in the response to family violence was affecting women and shaping their access to justice outcomes. So we had 2 overarching questions. One is around that impact of the change, and the second is seeking to explore solutions or alternatives in that sort of mix of services and supports that might be available. Really quickly, the methodology is a qualitative study. We set out to conduct semi-structured interviews. We ended up with 7 affected family members and 10 key informants from the wider justice sector. We did have a more ambitious sample than that, but we were disrupted, I think, in every way possible by COVID lockdowns. So, but the idea really was to develop typical cases that exemplify the circumstances and conditions of everyday or common situations of family violence. And so we worked with our legal practitioners to identify and screen clients into the study who could speak to those issues. And our analysis, which is still a bit of a work in progress, but we have these 3 overarching themes which characterize the work in the presentation today. Gatekeeping, which I'll talk about a bit in a moment, navigating, which my colleague Kate Clossy will talk about, and then advocating. Finally, I'll hand to Eva, who will talk about this, and we'll throw back to the wrap up after that. So gatekeeping, what we heard essentially when speaking to both AFMs and the sector stakeholders was that there are these individuals, powerful decision makers really, in key positions such as police or magistrates, that because of their roles hold discretionary power to decide who can gain entry to the family violence justice system. They make decisions about evidentiary thresholds and determine what information to record and pass on, and to whom. So when we looked at the accounts of the women that we spoke with, it was clear that this gatekeeping role creates this sort of funnel effect, whereby individuals move through an increasingly narrow range of legal options and processes. But gatekeeping can also facilitate access to justice outcomes. So, and in this sense, legal practitioners and social workers can use their expertise when they have the opportunity to translate technical information, to mediate between parties, or to broker connections between victim survivors and other actors in the wider system, and to ensure that they progress through the right gate at the right time. And just to provide one example of gatekeeping, and in the interest of time, I'll just provide one, but there are many in our data. So it's the example of Hannah, who found herself and her baby in hospital after a violent outburst by her ex, and actually he threw her into a wall while she was holding her baby. The police made an application for an intervention order. A full order was granted for 12 months. She moved in with her parents and tried to get on with her life. But during this time, Hannah said that her ex breached the conditions of the order, in her words, every opportunity he could get. And on one occasion, she went to the police and she said, you know, I remember it was around Christmas time, and the police officer had responded, oh, you know, they generally breach around Christmas because it's their first Christmas without their families. You know, they want to make contact, they want to see their kids. And she said it was just so blasé to them. It makes you so much more hyper-vigilant, because if the police can't help you, then who can? So what we think this example highlights is the manner in which police can act as gatekeepers of justice for victims through their attitudes, decision-making at different stages of the FVIO process. So the physical violence in the first instance was treated very seriously. It expedited an arrest and the granting of a full order. But these subsequent breaches were treated much less seriously in Hannah's view. And so what this meant was the protective function of the order ceased to be relevant effectively, and Hannah subsequently faced obstacles to obtaining another court order because breaches hadn't been well documented. So this is where gatekeeping is an important dynamic throughout our findings. Yeah, and with that, I'll hand over to Kate to talk about navigating.
Thanks very much. Hi, I'm Kate Clossy and I'm a researcher here at ARC Justice. It was my role in this research to speak to the women involved. I listened to their stories, and it was really clear that, you know, to keep the theme of navigating, the destination that they were after was not just the FVIO, the intervention order, it was actually to reach some form of safety and protection. So all of the women, as John said, were listed at some point in the system, not always at first, as AFNs on a police brought application. And they all described having to navigate a whole range of systems and services that got kicked off through this process. One of the women was negotiating with 7 different services to get safety for her and her children. It's not just that there's one service, or that the services around the different services can be tricky to navigate. It's also that the services themselves, they might intend to be victim-centred, but often they're not, and it's usually just a discrepancy caused by practical issues such as service design or funding models. So the court is one of those situations where the idea is that people are meant to get these access to them at court. And our project started because we were noticing that women were not necessarily coming to court, or they were being actively encouraged not to be. And then COVID hit and we moved to remote courts, and that just exacerbated that phenomenon. So even though they were not necessarily encouraged, they did often go, the women that I spoke to, at least to some of the hearings, and they described things like being stared at. They would find the ex standing in the doorway, blocking them from leaving. They would find them hanging around their car, and that was across, you know, these are common conversations that I heard. They didn't necessarily like being at court or feel comfortable there, and they didn't necessarily want to speak in the hearings, but that doesn't mean that they didn't want to be heard. So they also reported often not having a great idea about who they'd spoken to on the day, which really shows sort of the effect of that headspace that they're in on the day. And so there's a lot to be said about pre-court engagement, but I'm going to leave that for Hannah a bit later on. One of those services at court, of course, is free legal advice, and that's what we're here to talk about today. And that's usually offered for the uninitiated as a duty lawyer service. So you rock up on the day, you sign into the registrar, and you get asked whether you'd like to see a lawyer, and you say yes or no. Now, then you go off and you'll get the option of a free legal service from either a CLC or Victorian Legal Aid, the general model. If you're listed as an AFM on a police application, then you might already think that you're getting legal advice. So police are fantastic. If they're, you know, we have great examples where the police have explained the orders really well, that involve the women in decision making, but that's not independent legal advice. And it also doesn't capture the fact that someone involved with family violence is often likely to have a whole range of other legal needs that need to be addressed. Many of the stakeholders we spoke to said that they would only refer a woman off to a CLC or legal aid if they were disagreeing with the police about either getting the order at all or the conditions on that order. The other reason they might is if there's something to do with parenting or family law, but that was often seen as separate to the intervention order and not just sort of part of a giant jungle of systems that they have to negotiate. Before I said that ARC Justice was worried women weren't turning up to court to get legal advice, for the interviewees, the lawyer was often the difference between navigating or falling into what one of the women described as potholes. So, as an example, one of the survivor advocates recounted how a magistrate had stood down their order so they could sort out some kind of a parenting arrangement. They've gone outside, they've spoken to the ex-partner's lawyer who's there with a parenting plan all written out and basically told you can have this parenting plan and we'll consent to the order. So she didn't want to, but because she was involved with one of our integrated service partnerships, the lawyer that was there with her was able to help her to say no and help her go back to the magistrate and say that they hadn't resolved parenting, but she got her order anyway. Another example is a woman who her ex made just a spurious claim to child protection. It happened to be at a time when there was no one in the office at Child Protection who knew about what was going on and his history. And so the next thing you know, she's in an office and there's a meeting and there's a piece of paper that she's being asked to sign that consents to handing her children into out-of-home care. Once again, she was involved with one of our integrated service projects. She had a lawyer that she had a relationship with, and it was that being able to say, I don't want to sign this, I'm going to speak with my lawyer first, that stopped her feeling like she was railroaded into being in that system. So the focus today is on getting effective, independent and early legal advice. But I also wanted to highlight a really positive observation we had where that social worker or specialist family violence worker worked in tandem with the lawyer in those navigator and advocator roles. It's a model that really gets the most out of each of the specialties. And I'm sure it's part of the reason why a lot of the AFMs I spoke to were off to start new careers in social work now. And with that, I'm going to hand over to Eva, who's going to talk to us more about advocating.
Hi there, everyone. My name is Eva Lazaro. I'm a law student and a volunteer with ARC Justice. Before I begin, I would like to acknowledge that I'm speaking on the stolen land of the Wurundjeri people of the Kulin Nation. I pay my respects to elders past and present and acknowledge that sovereignty was never ceded. I would also like to acknowledge that the so-called justice system and the child protection system has been particularly violent towards Aboriginal and Torres Strait Islander families. Throughout the research process, we were interested in the question of what advocacy means for victim survivors of family violence, both within and beyond court, and how police brought family violence intervention orders shape access to advocacy for victim survivors. As a legal instrument, particularly when police operate as gatekeepers, FVIOs provide limited opportunities for victim survivors to advocate for themselves within the legal system. When police apply for an FVIO, they are representing themselves, not the affected family member. And the lack of transparency around this process can also limit access to lawyers and other support services, as Kate has highlighted, as victim survivors are often only encouraged to go to court or to seek independent legal advice in very specific circumstances. The brevity and the clinical nature of police-brought applications also fails to capture the trauma of family violence, often serving to disregard the experiences of victim survivors. One interviewee described the manner in which an officer read out her application as akin to reading out a parking infringement. Within this system, one of the only avenues victim survivors have to actually tell their story is in court, which is clearly an intimidating and adversarial environment. Across the legal system, and particularly with regards to family violence, we understand the need for victim survivors to be able to speak truthfully about their lived experience and the ways that family violence has affected their lives. So while police brought family violence intervention orders provide victim survivors with the opportunity to refrain from personally making an FEIO application and appearing in court, which can be challenging and at times a traumatizing process, this is too often coming at the cost of actually denying victim survivors their agency and voice. For many victim survivors that we interviewed, having an opportunity to speak to their lived experience was a really important part of access to justice and safety. One interviewee stated that being able to articulate what she had actually experienced to her family and friends was the thing that had the most profound effect on helping her to feel safer rather than the existence of the FEIO itself. Access to early legal support and advocacy, as Kate and John have highlighted, has the potential to help victim survivors, particularly those living regionally, to develop an understanding of the legal system and hopefully a greater sense of agency as a result. But it's also useful to consider the importance and utility of alternative forms of justice when thinking about advocacy, particularly in situations such as those in the study, where victim survivors are continuing to parent with respondents. A restorative justice framework may provide greater opportunities for victim survivors to share their stories and advocate for themselves. In situations where it's imperative that victim survivors maintain a relationship with their ex-partner, this framework provides an opportunity for reflection and accountability in a less adversarial and punitive context. That's about it for us today, or all we have time for, but you can read the full report, which should be published in early 2022, and our contact details are also attached there if you have any further questions for any of us. Thanks so much.
Fantastic. Thank you, everyone from ARC Justice. Hopefully I didn't get cut off then. I just jumped in there. Thank you very much. As everyone can hear, there's a lot to this research, and they're particularly highlighting the way that, as our consent orders research did, we sometimes mistake getting an order in play or an intervention order. We equate it with safety rather than a kind of mechanism that is part of the safety framework. And the ARC Justice research certainly highlights that AFM's understanding of what safety means for them can often be very, very different from the system's understanding, as well as highlighting some really fundamental misconceptions that we sometimes have about police-led applications, which are generally seen by the system as a really good thing, to be the same as somebody receiving independent legal advice. And that was certainly a misconception that we heard across our consent orders research. But for now, I'm going to keep things moving and pass to the fabulous Carmel Lowen from Youthlaw, who's very kindly joining us from the Territory to talk about Youthlaw's program working with young people and trying to bring them pre-court advice and engagement.
Thanks, Elena, and thanks everyone for being here today. As Elena said, I am one of the family violence lawyers at Youthlaw, and I would just like to acknowledge that I am on Larrakia country in the Northern Territory. I've made a beeline for the border, like many people have, after quite a few trying months in Melbourne, and just acknowledge elders past, present and emerging, and of course any Aboriginal or Torres Strait Islander people who join us here today. Youthlaw is a free legal service for under 25s. We're a specialist youth service and we operate Victoria-wide. I'm part of the family violence programme, which has 2 small programmes within it. And I guess when I thought of, can early access to legal assistance make a difference to safety, I was thinking safety of the young person and families, but also, and very importantly, safety to how we practice at Youthlaw and safety to how the court process occurs. So within the family violence programme, we have a dedicated pre-court AVIT programme. We also have essentially a duty lawyer service at Melbourne Children's Court, but both programs very much champion early access to legal advice. And to understand why that is so important, I might just set the scene of the cohort that we tend to see. We predominantly work with respondents, but as we know from our practice, at least 3/4 of those respondents are victim survivors in their own rights or have been exposed to violence. We know that many of them are perpetrating violence as a response to violence. So in terms of bidirectional violence, we know that some are mis-ID'd as primary aggressors. And we know that at times we have young people using violence against a parent or a sibling who has not been the perpetrator of violence, but they are a victim survivor also. We know that many of our young people have mental health issues, approximately 70%. I would say that in the last 12 months, that would be at 100% from my client base, with about 65% of those having diagnosis or awaiting diagnosis. Some of my clients have multiple diagnoses. One of my clients has 7 diagnoses. So it's a very complex group of young people that warrant quite intensive support. And, you know, we expect so much of these young people when it comes to the court process, yet the challenges that they face in attempting to engage with this system is really, really daunting. I often start from a place where I say, do you know what a lawyer is? And many times they say no, or I might have seen it on the TV. In terms of our program, we have the pre-court AVIT program, which is based in the West, servicing Werribee and Sunshine. Its goal is essentially to get young people between the ages of 12 to 18 who are using violence as soon as an application is made by police. That is a different context to what we see at Melbourne, because there is quite a heavy lag between application and listing in the West. So we're talking about potentially 3 to 6 months before that first mention, which is often time lost when you're talking about a young person turning up to court and getting a duty lawyer on the day. We aim to have progress made, plans in place, and the potential for resolution at that first mention. What that looks like, we practice an integrated practice across the program. So it's a lawyer and social work trained youth practitioner. We conduct a very wholesome and full intake. That in itself takes time. I'm sure many of you have had interactions with adolescents when, you know, 2 random strangers call. The first day you get barely anything, the next day you might get a bit more, but it takes weeks. It takes, will we go for a hot chocolate? It takes all of that to rapport build so that you're actually understanding what is going on. And we also know that safety can only be managed if we understand the context of violence. A safety plan, an application for an order, whatever it might be, if it's based on an incorrect context of violence, it really serves no purpose. So the lawyer and social worker will meet with the young person, will understand what's going on for them, will identify their legal needs and their non-legal needs. I can tell you now, all of the positive outcomes that we achieve with these young people legally are based on non-legal supports. We had one young man, he was 13, he came to the pre-court program via YSAS. So YSAS work alongside the police at the police stations. He came quite early. It was violence against grandma in the context of very acute mental health issues. Our lawyer and youth practitioner worked with that young man and hit the AFM, because what we find is that these young people are often heavily reliant on a parent or a caregiver to manage that episode in terms of referrals. And then, of course, once we had a bit of a plan for his non-legal needs, you have some ability to negotiate with police based on a non-legal support system. And on the first mention for that young man, the matter was able to be withdrawn because the supports were in place. Had that pre-court program not been there, what would have happened? The first day would have been a, hi, nice to meet you, I'm your lawyer, we need an adjournment to put some plans in place. It reduces the trauma of the court process, it reduces anxiety, it empowers the young person through knowledge, understanding. It gives them the opportunity to engage with the process, because we all know that often when the police turn up and they decide that there's going to be an order against a young person, although the guidance says you need to interview both people separately, the young person has often never gotten the opportunity to tell their side of the story. And so it was, you know, limited court interaction, but the safety was managed through means that will actually make a difference. Especially with young people, intervention orders, they might understand them a bit, but is it a deterrent? Often it's so beyond their capacity to address their behaviour without those non-legal supports that really, without the non-legal support, the intervention order itself is not going to make much difference other than criminalising a young person. The other aspect of our work is at the Melbourne Children's Court, which is a duty lawyer service, but it's pretty far from being a duty lawyer service. The Melbourne Children's Court, together with VLA and ourselves, are dedicated to getting those referrals as early as possible. The context is different because there's less of a lag at the Melbourne Children's Court, so we sometimes are talking about 2 weeks, 5 days, 2 days. But whatever it is makes a difference. It means that on that first phone call to the young person, you can have a chat, you can build rapport, and the next day when you call again, you can tell more about the process. Young people often have no idea what's going on. They know that the police have shown up. They don't really know anything else. We are experiencing high number of misidentification cases. So the first aspect of that is rapport building. The next aspect is saying to a young person who's a victim survivor, hey, actually, your parent has taken an application, or the police have taken an application and they say that you've done X and Y. That has to be really carefully managed because that is a very distressing proposition for a lot of young people who are victim survivors. And you are, many steps away from trying to talk to a young person about addressing those allegations. Hey, this is what was said, we can deal with that. But actually, in order for you to be safe, the police and the courts need to know the truth about what's going on at home. And it's easy for me to say, you should apply for an order. But when you think about it, the young person probably lives with the parent. They're probably financially dependent on the parent. They might need school clothes, school books, ID. It's endless what these young people are facing just to try and make sure that they're safe in an environment where a police officer has told them that they're the problem. And so when we do that rapport building, a lot of it around the legal assistance is just because the police have said this isn't the end of the story. We're here for you to advocate, to tell your side of the story, to listen. This isn't the end of the story, it's the start. And that takes extensive lengths of time. We, like I said before, we expect a lot of these young people, but as a system, we really need to be acknowledging the cohort of young people that find themselves in this position. And like I said, we're talking about victim survivors, we're talking about young people dealing with trauma. And in order for us to be safe, it needs to be trauma informed, which takes time. It takes rapport building, and it takes a real commitment from everyone. And that's CLCs, that's the police, and that's the court system to move in a way that provides the space and time to truly understand the context of violence. And we see that it improves the safety of young people and families by linking young people into services. There's often delay with that. So we need time, 6 to 8 weeks to get a young person into a service. It increases their engagement with the process. I've had many young people go to ground if I expect them to talk to me on the first day and turn up at court. So are they getting, full access to legal assistance in that situation? No, and we definitely need time. It reduces, orders being made for, where an interim is made. It gives the young person the first available opportunity to say, actually, they've told me I can't go home, but I've nowhere else to be. And my parents want me at home. It gives the young person the capacity to say, actually, this happened and it's not right. It increases compliance with orders. If they do exist against a young person, it's not, there's no obligation for someone to make sure that a young person understands an interim order before there's one in place, which of course leads to the criminalisation of young people if they don't understand. And it also, like I said before, it empowers and it invigorates young people to understand their rights, to understand the system, which all leads to a safer environment for all, regardless of status of perpetrator, AFM, or the public generally. I think that's all from me.
Fantastic. Thanks so much, Carmel. And as Carmel and ARC Justice's presentations have highlighted, just the complexity involved and the kind of hugely varied and diverse supports that contact with legal advice at the earliest possible point can make in the difference to safety, I think. And there's actually a question coming through about a lot of acknowledging that a lot of CLCs have great early intervention strategies incorporating legal advice for victim survivors, but it's certainly something that I think is not the complexity and the depth that is involved in access to legal advice is not necessarily something that's well understood across the system. And one of the things that we certainly recommended in our consent orders research, which predated COVID, but I think a fair bit, some themes have been picked up, will be picked up in the next presentation, but also in Carmel's reflection about the time that's needed, and that sometimes we think that the answer to volume is to speed things up, but sometimes we actually need to slow things down so that we get it right in the first place and don't cause more harm than good. But I'll throw now to Hannah Fernside from VLA, who's here to tell us about the early resolution service and some of the efforts that have been made there to address these very concerns.
Thanks, Elena. Hi all, I'm Hannah. I'm here from Victoria Legal Aid. I'm a lawyer in the Family Violence Program and Project Coordinator. Before I begin, I'd also like to acknowledge the traditional owners of the lands I'm on here in Melbourne, the Wurundjeri Woiwurrung peoples, and in acknowledging these traditional owners today, I'd also like to recognise that conversations about access to justice have been occurring on this land for thousands of years. So Victoria Legal Aid, we're a statewide organisation. We've got 15 offices located across the state. We provide free legal information, education to all Victorians, and then we prioritise more intensive legal services for people who meet eligibility criteria. It could be based on financial situation, nature and seriousness of their problem, and their individual circumstances. Here at Legal Aid, we occupy an important space in the family violence sector in the work that we do, and like many organisations in this space, the COVID-19 pandemic really drastically changed the way we were delivering our family violence services, and it also saw a real increase in the delivery of pre-court advice and online service delivery by our lawyers and our staff. So in adapting to this pretty swiftly changing landscape, it feels like a lifetime ago now, but way back in 2020, lawyers from our Legal Aid office in Frankston, along with our friends at our Peninsula Community Legal Centre, began engaging in some pre-court advice work and negotiation with a view to resolving. And when I say resolving, not just getting to the point, we've had a bit of discussion about final consent orders so far, but even a resolution could be, an agreement between the parties for an adjournment, for a risk assessment, or to put other safety measures in place, such as giving a respondent time to engage with a men's behaviour change program or other programs. So getting to the point where a resolution could happen for family violence matters before that first listed mention date. On the ground, we found that many matters were resolving following that pre-court legal assistance, and it saw a reduction in matters that were being added to that pending intervention order caseload. So this work then became known as the Frankston model, and following its success, we were lucky enough to get some funding through the state government through the Justice Recovery Plan to use it to put towards the expansion of this pre-court assistance. So the program, depending on where you are, may be called the Early Resolution Service, or you may have also heard be called the Pre-Court Engagement Service. So it commenced in May 2021 with an aim to continue the good work of the Frankston model and to provide people with family violence legal needs with timely, high quality legal services in a way that was safe and supportive, whilst also reducing the need for victim survivors to attend court, reduce demands on the court day and increase the capacity of duty lawyers. And we couldn't have predicted, I think probably in May, that we would have another year quite like 2020. So definitely has been of great assistance with the move again to largely online family violence services this year. So the ERS project, it's a co-sponsored project between Victoria Legal Aid and the Federation of Community Legal Centres. We've got some other funded practice partners, including the Magistrates Court of Victoria, our Community Legal Centre friends, Victoria Police, and specialist legal services in JIRA and the Victorian Aboriginal Legal Service. So at this point in time, the ERS it's currently operating at 7 Magistrates Court locations, including Dandenong, Melbourne, Broadmeadows, Sunshine, Werribee, Ringwood and Morwell. And with all new projects, the project team, we've definitely encountered both challenges and benefits across the year. We've found that the demand, I suppose probably unsurprisingly to all in the room here, is really high. Almost everyone who's been offered the choice to receive pre-court advice took up the option, which is really great. We've found some challenges to the program's success in terms of current demand and resourcing pressures, which I'm sure is probably not new to everyone here either. Sufficiently resourcing this project remains a challenge, as the demand is just often outstripping the capacity of our officers and our partners. We've also found that it generally takes a bit longer for our lawyers to provide this sort of comprehensive early resolution service. If the client's not available when first contacted, there might be more admin work involved with setting up these advice appointments. And of course, we all acknowledge the ongoing impact that remote work and the pandemic has had on the success of this project so far. One of my colleagues, who I think is on the line today, Beth, referred to it as building the plane while you're flying it, which I really like. So we're working on embedding and refining this process in a way that works in a changing legal landscape, but it's also across multiple agencies. So, you know, including legal aid, CLCs, police, the courts, and we want to make sure that it's consistent across all of our partners. Anecdotally, it seems to be that the impression we're getting is that the model is showing the potential to really contribute towards reducing demand on our court registries and on our duty lawyers long term, which is really good news. We've been really proud of the interagency collaboration and engagement and support of the project that we've found from all of our partners. It's great to see all the agencies working together and being really proactive in terms of reaching a resolution where appropriate and safe advice can be given. Not all matters are appropriate for the early resolution service. So say where a client might be unrepresented or not engaged with another service, they don't provide consent to engage with the ERS project, or that, you know, that there's an assessment made either by one of our partners or by the lawyer that there's a power imbalance in negotiations or whatever it might be. Not every matter will be suitable for the ERS. The project is I think, really helping clients to have that real early access to legal advice. And I also do a bit of work as a duty lawyer, so I've been able to see some of the benefits of this in practice, where, you know, we're getting clients coming into their first mention, having had the benefit of a bit of pre-court advice and have already started turning their minds to their options, or you know, have been linked into support services prior to court. And it means that for duty lawyers, it's streamlined. For clients, it's streamlined. It's not such a long day then at court for them, and, you know, that we can hopefully then avoid some of the delays that have been found around you know, COVID causing delays to further mentions. I suppose the best thing is that with that pre-court advice as well, is that it really gives clients the time to consider that legal advice, rather than being in that high pressure environment of court, of having to do that on the fly. In terms of the future of where this project will be going to next, the funding was approved for 12 months at these 7 locations. An evaluation will take place at the end of this period early next year to determine you know, the best method of delivering these services going forward, taking into account that I think remote working and remote duty lawyering and remote legal advice and all of those things are probably here to stay, and we'll be implementing a bit of a hybrid model going forward, and considering in terms of where we would expand to next if we were to add other court locations to service in the ERS model as well. I'm happy to take any questions, Elena, if anyone's got questions about that.
Fantastic. Thank you, everyone. Can I just certainly invite some questions from the audience but I've just got a couple of my own that I'd like to put to people. And I think, Hannah, you certainly raised the issue of sort of where to from here in terms of that hybrid expectations about hybrid ways of working. And I think it would be good to sort of hear from the different panel members of what your reflections are, because now that courts have done the gargantuan and previously unthinkable task of moving to the online world, there are efficiencies gained and potentially assumptions made, including across government, that that's the answer to the backlog that we'll be facing. But all of the complexity that people have described here today shows that there are lots of benefits to different ways of engaging with people, but sometimes that they can be a lot more time consuming than just engaging face to face and being able to sort of get the full sense of what someone's experiences are. So perhaps, Hannah, I'll throw back to you and ask for your reflections as someone who also works as a duty lawyer and things. How should we be striking the right balance?
Oh, it's a difficult question, Elena. I think it's one of those how long is a piece of string sort of questions, but I think there are definitely in my practice work and, you know, sitting in a bit of a hybrid role myself doing duty lawyer work and project work, that there have certainly been benefits that none of us anticipated the hybrid model could bring in terms of parties being able to, in circumstances, engage more safely in the court process, to feel more included in the court process if court facilities are not accessible or interpreters are not available, or, you know, all of those things that can make courts inaccessible at times. I think you're absolutely right in that, assuming that, you know, great hybrid model, awesome, let's just keep it all going as it is going to be the cure to what is, I think, not an insignificant backlog that we'll all be facing in terms of matters at the start of next year, is a bit of a, it is not going to be the cure, I think, that everyone would hope it would be. And I think definitely the benefits of this early advice that we're seeing on the ground and that I'm hearing from the other members of the panel, if we can get it to a point where, you know, it's streamlined between all of us as agencies in terms of, you know, legal services, the court, police, you know, and other agencies, if we can get it to a point where we're prepared to do a bit of a combination of pre-court advice, pre-court negotiation, pre-court resolution, in-person duty lawyer services, online duty lawyer services. I think, yeah, it's going to be hybrid, not just in the sense of online and offline, but hybrid in the sense of combining all of these great things that have been happening to help us limp along during COVID. I think adding resources to that and expanding that is definitely how I see the expanded version of hybrid working anyway.
Thanks, Hannah. And just a quick follow-up question from the audience: is the ERS service provided to everyone as an option, or are there certain criteria that need to be met before referrals are made?
Sure. So look, for parties who want to engage in our ERS service, there's a form that needs to be completed with the court. So basically they can get some details and consent from you. That's probably the biggest hurdle I think we're finding in terms of referrals happening, is getting people to, you know, complete these forms, get them done in a time that's not, you know, the day before court, in terms of getting that advice nice and early. So if you're in one of our 7 court locations that are under the pilot and you've got parties that want to engage in this ERS service, definitely getting in touch with the court and getting that notice of address and consent form done as quickly as possible is definitely the easiest way to get into that ERS service.
Fantastic. Thank you, Hannah. And now I'm going to throw to the other members of the panel to reflect on 2 things. That question about hybrid models, ways of working, because I know there are different considerations for different parties to FEIOs on that matter. But there's also been a question come from the audience to ask about the role of undertakings and how they fit in with the system at the moment in preference to an IVO. So, and I know, again, that's very different in terms of the different cohorts that the services are trying to support. So, Carmel, I'll go to you first.
Yep. So I think in the first instance, in terms of, I guess, what life post-COVID looks like, I think I agree with what Hannah was saying. I think the actual structure of the court day may be less important if there is the opportunity for early referrals and early work to be done, because the anxiety that comes with the unknown of the court day is what's crippling often for our clients. I have found in the online environment there has been a real understanding of young people's complexities and a real willingness to accommodate them. So, for example, being excused due to mental health concerns, being excused due to excess anxiety about the day is sufficient for most magistrates to make alternative arrangements for the young person where they are the respondent and are technically required to attend. I think if we've learned anything, it's that things can work differently, and at the Melbourne Children's Court, each matter has an allotted time slot. A young person has certainty about how long it's going to take and when it's going to be. You can tell them, if you don't hear from me at 12 o'clock, that means you're not required. And I've had a couple of young people say to me, thank you so much for saying that, and thank you so much for saying not to expect your call until whatever time, because I would have been waiting. And it's tiny little things like that that might be nothing to a practitioner, but actually to a young person who's anticipating something that's really, really scary, can make all the difference. So I would like to think that regardless of what we do next, that we take the learnings from what we've done really well now with us. And in terms of the undertakings, that is something that we see a lot at the Melbourne Children's Court. It is widely practiced within my own client group, at least, where respondents matters will resolve on undertaking, in particular, again, where we have quite a good non-legal support structure in place. So it may be that the young person makes an undertaking that they won't use family violence, but also that they'll go to school and they'll see their support workers, whoever they may be. So it's essentially a second chance, an opportunity to engage and to make things different without the court process hanging over them, because again, it reduces the interaction with the court system, reduces that trauma, but you still have what I think as a really valuable interaction with a service like Youthlaw, because all of a sudden a non-serviced young person is being serviced and has sort of a very limited interference going forward in terms of the legal side. So they are used quite widely. And magistrates really want to see them in child-friendly language so that they have some meaning to the young person.
Fantastic, thank you. ARC Justice, I'm not sure who to throw at John, Kate, or Eva, who to throw at Kate will. If you could reflect, obviously there on relation to undertakings is quite different in the adult context, the significance for AFMs, but also thinking about what the shift to remote courts has looked like and should look like from your perspective in terms of servicing clients, particularly in regional Victoria.
Thanks, Elena.
Sorry, we're going to Kate. Yep, thank you.
Thank you. Yeah, so I think one of the things that I sort of touched on earlier was talking about the idea of courts as service hubs. So that's a very physical space. There has been, particularly since the Royal Commission, there's been massive investment into putting those services into those court spaces. And of course, if you're doing it all remotely, you don't have access to that anymore in that same way. So you have to shift the way that we get those services to people. And in some ways that can be really positive. So from a resourcing perspective, just the simple, we cover these 8 satellite courts and they're all travelling from our 2 key offices in Shepparton and Bendigo. We can sort of interact with the clients we have in those smaller centres a lot more easily when we can get to them earlier, which having that remote access of courts has encouraged that. Obviously, you can't just turn up on the day in the same way you could physically, but at the same time, there's dangers there, and there's dangers because you don't have eyes on people and where they are and whether they're safe in that environment. And then there's very practical things. We don't have awesome internet always in the country areas either. So there's all of those practical things to consider as well. In terms of the service design of courts being that service hub, the other thing that's really changed and was completely evident when I was speaking to the women, often they'd been at both the bigger courts and the smaller courts as part of their often very long process of being involved with this system. And one of them, I wish you could have seen her face when she sort of was describing just the experience of being in the small court where she's stuck in the same room, that heightened sense all day. That whole time you're talking, Carmel, about having an actual appointed time, not being stuck there all day waiting for your matter to come up. And then she was speaking about being in one of these big courts that have all of these bells and whistles, and the design is completely different. There's safe spaces that you can be. You can have that time when you're waiting to engage with these services that are all there for you, because you're not having that feeling of being hyper vigilant, which is exhausting. So there's really good things happening about being on location, particularly in those courts. There's a very big question our system is going to have to consider now about that discrepancy between what's available at the big courts compared to the small courts. And third one is, the remote thing. There is some good things. It's brought about this pre-court engagement, which it's got great potential to do a much better job of servicing the needs of clients and getting them an outcome that is more about safety than a piece of paper. But it is also has these other dangers and practical issues involved too. And so I don't think it's going to be the big answer to everything. We can't just smash them through because we can do it all online. We really need to work out what's the way of going forward that works for the actual parties involved. And that comes back to the undertaking. Again, an undertaking can be great, but they need to be really well crafted by people who are skilled in understanding all of the range of issues that are affecting the safety of that couple. They're not appropriate everywhere. And I know certainly we've had lawyers come back from duties talking about having to, they've got a client who's accepting an undertaking that they really didn't think that was necessarily in their best interest. But in the duty environment, there's not necessarily the time to really unpick that and give someone time to think about it either. So yes, undertakings can be great, but they need to be in the right circumstances, and you actually need time with your client to understand those circumstances. That would be my summary on that one.
Yep, fantastic. Thank you, Kate. And speaking of time, we have actually hit time, but I think there is a final question about sort of increase in demand being offset by sort of different energies being put in different places that we might sort of see if we can follow up in a different context. But I think it goes to the heart of that matter that really what we've been talking about here is perhaps upending that assumption that things, as I said, need to be sped up to deal with the demand, that if we can get things right, if we can get the quality of the interaction and put supports around people from the outset, then not only is their safety going to be increased through just this contact with services, but their understanding of the process, understanding of what that piece of paper might actually say is going to increase. So there's all sorts of kind of quite things that might appear to be intangible, but make a huge difference to the quality of outcomes that mean that we don't see people coming back. If we can increase the effectiveness of this process, not just ensure that it's terribly, terribly busy, we might actually have an impact on that demand down the track. And that's certainly what we said in our consent orders research all those many years ago in the pre-court, pre-COVID world. But it seems to be being the themes that are coming out here today. So I thank you everyone for joining us, and I'd invite you to certainly keep an eye out for ARC Justice's research when it comes out next year. and there'll be evaluations of the Youthlaw service and the VLA early resolution service coming out as well next year, which we'll be sharing from the CIJ and our other networks. So it's a really just a beginning kind of conversation about how do we get the best outcomes when people come to the court, so that their safety is increased and so that they don't have to come back again. All right. Thank you very much, everyone, for coming, and Merry Christmas.